рада
the
приветствовать.
participants to join. I'm happy to see you
Сейчас
all.
хотелось бы сказать о том, что
Now, I would
мы
like to say
продолжаем.
that
И сегодня у нас идет
we
четвертая уже
are
дискуссия по
continuing our
рекомендациям
work. This is
четвертого
the fourth
цикла мира.
discussion
Чего видно,
on the
да?
fourth cycle of UPR.
Да, видно вас, ага.
Видно, да? Всем видно, слышно. Еще немножечко подождем. Так, видим,
So let's wait
подключился.
a little
Пара
while.
подключилась, но основные участники у нас подключены. Итак,
So
я рада
our
всех
main
приветствовать.
participants
Хочу
are
напомнить
online. I'm
следующее,
happy to see you all.
что
Let me
все,
remind you of
кто
something.
не участвуют в дискуссиях, желательно отключить ваши микрофоны,
Please
чтобы мы не
turn
мешали
off
друг
your
другу.
mic
Но видео
if you are
свое
not
вы
part of
можете
the
подключить.
discussion,
Еще у
but
нас
you can
работает
keep
кнопочка
your
«Перевод»,
camera
потому что у
on,
нас
and also we are providing the interpretation service. Because we are expecting representatives from different countries. And let me start our fourth discussion. Alexander, please let me know if the recording is going on and whether the live broadcasting is on as well. And this meeting is hosted by Kadir-kasiet, coalition of human rights defenders, and this initiative was supported by the Global Association Against Torture and International Service for Human Rights. And the goal of the discussion today is to talk about the issues, discuss some updated information and relevant issues related to the recommendations that Kazakhstan will receive under the UPR, the working group on UPR, in accordance with Resolution 5/1 of Human Rights Council, had the 48th session in January 2025. The Kazakhstan's review took place on the 23rd of January, and the delegation was led by Ilan Tarsanbayev, Minister of Justice. At the 16th meeting, the working group approved the report on Kazakhstan, and during the interactive discussions, 103 delegations delivered their statements, and you can read their respective reports on the website. And today we have human rights defenders who prepare their review on selected topics. They will give their recommendations on further improvements. Let me remind you of the historical data. The working group of the Human Rights Council of UN provided 245 recommendations under the UPR. In January 2020, 214 recommendations were accepted by Kazakhstan and 31 declined. And 129 recommendations given in the first cycle. In the second one, 198 in the third cycle, 247 recommendations given, including 51 on women's rights, as well as gender, 8 on civil society, and 3 on human rights defenders. And let me say that Kadir-kasiet, back in 2024, this public association prepared 3 reports on human rights defenders, on women's and girls' rights, as well as against torture. The reports were prepared together with human rights defenders and associations supporting the initiative. And once again, let me remind you that we are having discussions every fourth Wednesday, and you can watch us on the Dignity channel broadcasted live. If you couldn't join, you can always refer to recorded videos. Let me turn the video on. A video graciously provided by International Service of Human Rights. Javier is delivering this video. It's night time in his country, but we can still watch his recommendations on the screen. Let me turn them on. Let me remind you that you had a chance to meet Javier personally. Technical issue.
Включаю, да, тогда демонстрацию?
Мгм.
how these relate to international standards for human rights defenders, especially those enshrined in the Declaration of Rights. So, what are the recommendations that we are going to be talking about today? These recommendations are those under section 139.44 and onwards of the UPR matrix. These include explicitly prohibit any form of discrimination based on sexual orientation and gender identity made by Spain, adopt comprehensive anti-discrimination legislation that includes an explicit prohibition of discrimination on the basis of sexual orientation and gender identity by Australia, adopt comprehensive anti-discrimination legislation which includes sexual orientation and gender identity as protected in grounds by Sweden, adopt comprehensive legislation against discrimination, including discrimination based on sexual orientation and identity by Chile, adopt comprehensive anti-discrimination legislation that addresses direct and indirect discrimination and encompasses all the prohibited grounds of discrimination, including sexual orientation and gender identity by Iceland, adopt specific legislation to eliminate discrimination in which all prohibited grounds of discrimination are specified, including sexual orientation and gender identity by Mexico, adopt legislation that expressly guarantees protection of lesbian, gay, bisexual, transgender, and intersex persons against discrimination and violence, provides for the full enjoyment of the rights, recognition by rule of life, amend existing legislation to prohibit discrimination against women and on the basis of sexual orientation and gender identity, made by Canada, adopt comprehensive legislation against discrimination, which includes direct and indirect discrimination and all grounds of discrimination, including gender, disability, religion, ethnicity, sexual orientation, and gender identity, made by Honduras. Amend the Article on Violations of the Equality of Human Citizens, Article 145 of the Criminal Code, to explicitly and separately include sexual orientation and gender identity as protected characteristics. It was made by Belgium. And continue its efforts to combat discrimination against women. This was made by Tunisia. As you can see, the majority of the recommendations relate to gender identity, sexual orientation, and gender. So that is the reason why we are focusing on one of the groups that mostly relates to these areas that are being discussed, which is women human rights defenders. That is women who defend human rights and those who work on the rights of women. So we are comparing these recommendations and the standards of women human rights defenders with the Declaration Plus 25. In previous sessions and previous videos, I have already explained the contents of the Declaration Plus 25, so I will be very brief. As you can see, this document, the Declaration Plus 25 is a civil society-led document that was prepared and compiling legal developments on the rights of human rights defenders and the obligations of states and other actors that have been developed worldwide over 25 years since the original Declaration of Human Rights Defenders was adopted by the UN in 1998. It is meant to serve as a supplement to the UN Declaration. It is meant to be read alongside it. Together, they set the parameters and standards to protect the right to defend rights and those who exercise it today and for the next 25 years and beyond. While the Declaration is a civil society document, it has already progressed in the fact that it is already being recognized by other UN bodies. For example, in the 58th session of the Human Rights Council, which just took place at the beginning of this month, April 2025, during one of its resolutions, in the preamble, they noted the existence of the Declaration for 25. The document thus is becoming soft law, and it is important that we continue using it and acknowledging it so that its standards continue to be used by high courts, tribunals, and authorities, and then make sure that the protection of defenders follows the most progressive international standards. So now, having explained what is the Declaration for 25, we will focus on which parts of the Declaration mention important aspects related to women human rights defenders and those who are gender diverse or of diverse sexual orientations. First, we move to the preamble, which acknowledges the role and contribution of women human rights defenders and is deeply concerned by the specific challenges and risks they face, including gender-based violence and discrimination, intensified by the intersection with other forms of discrimination, including discrimination based on race, age, religion, caste, ethnicity, education status, political opinion, disability, sexual orientation, gender identity, expression, and sexual characteristics. So here we see that even just from the beginning of the Declaration Plus 25 on the preamble, it is already recognized the major role that women human rights defenders have in the protection of human rights and how their rights can be particularly affected with the intersection with other aspects of their identity, including gender identity and sexual orientation. However, it is not only in the preamble that we recognize these parts of the identity of a person. We can move on to Article 3 on the recognition and acknowledgement of the right to defend human rights. This article, quite important, recognizes that a violation or abuse of the right to defend human rights constitutes a violation or abuse of the human rights and fundamental freedom being promoted, defended, or protected. States should recognize and publicly acknowledge the right to promote, defend, and protect human rights and fundamental freedoms, and those who exercise this right. On this article, the Declaration 25 recommends on subsection C that states should foster a culture of respect for and protection of the right to defend human rights within state institutions, including through the provision of mandatory training programs for law enforcement and judicial officers and other public officials on the right to defend human rights and the importance of human rights defenders' work or activities. whether carried out individually or collectively, adopting an intersectional and sensitive approach to gender and diversity issues. So we can see from Article 3 that already it recognizes that the right to defend human rights, in order to be properly defended and guaranteed, it not only requires a general approach recognizing that such a right exists, but also a specific and gender-based approach that analyzes how this right is exercised by women and gender-diverse persons and how this right should be protected in these specific cases. We then move on to Article 4, which recognizes the right to a safe and enabling environment for the exercise of the right to defend human rights. We have discussed this article in previous sessions, and you will surely know that it is quite extensive. But right now, we only focus on the obligation that states that particular states shall give special attention to the risks and challenges faced by women defenders and those working on women's rights and gender issues. Again, we recognize that in order to protect and properly defend human rights, specific attention must be given to women's human rights defenders. Then we move on to Article 6, on safety and protection of human rights defenders at risk. And you can see this article covers most of the screen, and that is because there are several sections of this article that are particularly specifically relevant for the situation of women human rights defenders and the protection of gender rights and gender issues.
Индира, извините, вот вы выключили звук, и вообще сейчас ничего никому не слышно, потому что Хавьера не слышно, перевода тоже нет. То есть мы...
Одну секундочку.
Когда вы звук выключаете свой, тогда и Хавьера звук пропадает.
Хорошо, как мне сейчас сделать перевод?
Просто не отвлекаться и сделать погромче свой звук, чтобы переводчик слышала хорошо, потому что Софья не слышит.
Хорошо. Так, ну, у меня звук стоит на максимальном управлении. 100.
Запись включить тогда.
Все, включила.
Нет, вы не включили запись Хавьера, вот сейчас его нету.
Сейчас. Включила, да?
Or any other form of adverse action by state or non-state actors, including business enterprises, including due to their identity, including their age, sex, sexual orientation, gender identity, expression, and sex characteristics, race, caste, color, and others, which we will skip for the time being. Subsection B states their work or activities in the promotion, defense, and protection of human rights, including on or offline communications, journalism, media work, and legal work. And Section C says the issues on and context in which they work, including women and gender rights, LGBTQIA+ rights, climate justice, land and environmental rights, digital rights, and others that you can read on the screen. Article 9, which refers to access to information and communication technologies, or ICTs, and protection against new and emerging forms of technology-facilitated rights violations. This article states that states shall adopt legislative, policy, and other measures to protect rights to freedom of expression and privacy, and ensure protection from all forms of digital harassment, including technology-facilitated gender-based violence. Noted that states themselves or their proxies are often the perpetrators of such violations or abuses. They must ensure the protection and enabling of human rights in the digital realm. Subsection D specifically mentions that states should take all necessary legislative, administrative, technical, and other measures, including ensuring private sector accountability to prevent, remedy, and eliminate cyber harassment, including technology-facilitated gender-based violence, smear campaigns, doxing, the spread of malicious or deceptive generated media, and other threats against human rights defenders. This includes when states or its proxies are themselves the perpetrators of such harassment. The article also indicates that subsection F indicates that states should implement a ban on sale, export, transfer, and use of surveillance technology until human rights safeguards are in place. This should include a ban on uses of facial recognition and remote biometric recognition technologies that enable mass surveillance and discriminatory targeted surveillance, including so-called emotion recognition and gender detection technologies, which fail to respect human dignity and violate human rights by design. As you can see on this article, the Declaration Plus 25 explicitly recognizes some of the particular risks that women human rights defenders face with regards to technology.
Дира, извините, пожалуйста, вот здесь поступила просьба от переводчицы Софии. Вы видите, да, в чате? Обратите, пожалуйста, внимание. Здесь очень важно, чтобы все участники, во-первых, сегодняшней дискуссии, а во-вторых, те, кто будут смотреть нас в прямом эфире сейчас, да, на канале Dignity 5351, плюс в записи на русском, на английском языке, чтобы у каждого была возможность услышать перевод. Просто у меня сейчас нет возможности качественного интернета, чтобы бесперебойно. Поэтому я попросила вас, если можете, там нужно сделать остановку сейчас и параллельно с переводчицей включить видео, тогда она сможет параллельно переводить в Zoom. Просто сейчас договоритесь, пожалуйста, Софи, как это лучше сделать. Можно прямо сейчас в прямом эфире, я думаю, что это будет нормально.
Я подключаю
Самое
перевод на
главное-
русский.
Да, самое главное, чтобы вы просто с Софией сейчас координируйтесь, как это сделать, и Софья ответит, ну, прямо вот здесь, в эфире. Потому что иначе
Софья,
смысла нет у нас, да. Нужно, чтобы вы понимали.
Софья, я включила перевод русский. Так, видео, может быть, мы тогда его чуть раньше. У меня 11 минут 44 секунды.
Ну, а вот эти 11 минут никто же не понял, что о чем была речь.
Хорошо,
Индира,
давайте мы
давайте
поставим на
чатики
начало
взялись
видео.
модерировать, пожалуйста.
Так, я ставлю на самое начало. Софья. Хорошо. Я тогда подключаю демонстрацию экрана. Все верно? Все с самого начала.
Hi, everybody.
Все, начинаем.
It is a pleasure to be again here with all of you to discuss Kazakhstan's recommendations on the Universal Periodic Review for its next cycle. My name is Kadir-kasиет. As you may know, I'm a legal officer. Right?
Принятие конкретного законодательства для устранения дискриминации, в котором указаны все запрещенные основы.
discrimination. It includes direct and indirect discrimination on grounds of race, gender, disability, religion, ethnicity, sexual orientation, and amend the article on violations of the citizens 145 of the criminal code to explicitly and separately include sexual orientation and gender identity, sexual characteristics, and continue its efforts to combat discrimination against women. As you can see, the majority of the recommendations relate to gender identity, sexual orientation, and gender. So that is the reason why we are focusing on one of the groups that mostly relates to these areas that are discussed, which is women human rights defenders. There's women who have human rights, and those who work on the rights of women. So we are comparing these recommendations standards of women human rights defenders to the Declaration of 5. In previous sessions and previous videos, I've already explained contents of the Declaration plus 25, so I will be in this document. Declaration plus 25 is a civil society-led document that was prepared and compiled in legal developments, rights, human rights defenders, organizations of civilians, and other actors that have been developed worldwide from the 25 years. The original Declaration of Defenders was adopted by the UN in 1998. It is meant to serve as a supplement to the UN Declaration. It is meant to be read alongside. Together, they set the parameters and standards to protect the right to defend rights to those who exercise it today or the next 25 years and beyond. While the declaration is a civil society document, it has already progressed in the fact that it is already being recognized by other UN bodies. For example, the 8th session of the Human Rights Council just took place of this month, April 2025. During one of its resolutions in the preamble, they noted the existence of the Declaration of 25. The document thus is becoming soft law, and it is important that we continue using and acknowledging that its standards need to be used by high courts, treaty authorities, and then make sure that the protection of offenders follows those progressive international standards. For now, to explain what is the Declaration of 25, we will focus on which parts of the Declaration should important aspects related to human defenders and those who are gender diverse or of diverse sexual orientation. First, we move to the preamble, which acknowledges the role and contribution of women human rights defenders and is deeply concerned by the specific challenges and risks they face, including gender-based violence, intensified by the sexual discrimination, race, age, religion, caste, migration status, political opinion, disability, sexual orientation, identity, expression, and characteristics. So here we see that even just from the beginning, the Declaration of 25 on the preamble, it is already recognized the major role that human rights defenders have in the protection of human rights and how the rights can be particularly affected with the intersection with other aspects, including gender identity and sexuality. However, it is not only recognize these parts. First, we can move on to Article 3 on the recognition and acknowledgement of the right to rights. This article, quite important, recognizes that a violation or abuse of the right to rights constitutes a violation of abuse of rights that being promoted, defended. States should recognize, publicly acknowledge the right to promote and protect human rights and those who exercise rights. This article, the Declaration of 25, recommends Section C that states should foster a cultural respect for and protection of the right to rights, including through the provision of mandatory training programs for law enforcement and judicial officers and other public officials on the right to defend human rights and the importance of human rights defenders' work or activities that are carried out individually and collectively, adopting an intersectional and sensitive approach to gender and diversity issues. And we can see from Article 3 that already recognizes that the right to defend human rights in order to be properly defended not only requires a general approach to the special rights system, but also a specific and gender-based approach that analyzes how society sexes are human gender identity and how these rights should be protected. Then move on to Article 4, which recognizes the right to a safe and living environment and exercises the right to rights. Let's discuss this article in previous sessions. You will surely know that it is quite extensive, but right now we only focus on the obligation of states. In particular, states shall give special attention to the risks and challenges faced by human dependence, with working on women's rights and their issues. We recognize that in order to protect human rights, specific attention must be given to human rights. Then we move on to Article 6 on safety and protection of human rights defenders at risk. You can see this article covers most of the screen. That is because there are several sections of this article that are particularly specifically relevant for the defenders and rights and we agree. It shall recognize, prioritize, guarantee safety of all defenders, particularly those at risk of who are detained with violence, threats, retaliation, prohibited discrimination, pressure, intentional or systematic exclusion, marginalization, oppression, or any other form of adverse action, including business enterprises, including due to their identity, age, sex, orientation, gender identity, expression, characteristics, race, caste, color, and others which we will skip for the time. It subsection B states the worker activity in the promotion of rights, including on or offline communication, journalism, video, work for video. Section C says the issue on and context of work, including women and gender by employees' rights, climate justice, and environmental rights. Article 9. It refers to access to information and communication technologies for ICTs and protection against new and emerging forms of technology facilitated rights violations. This article states states shall adopt legislative policy or measures rights, privacy, issue protection from all forms of sexual harassment, technology facilitated gender-based violence, including that states themselves or the proxies are often the perpetrators of such violations and abuses. They must ensure the protection and enabling rights of the mentions that states should take all necessary legislative, administrative, technical, and other measures, including ensuring private sector accountability, and remedying and cyber harassment, including technology facilitated gender violence, smart of malicious or deceptive video, and other threats against human rights defenders. It includes when states or its proxies are themselves the perpetrators of such harassment. The article also indicates that in section F, it indicates that states should implement a ban on the sale, export, transfer, of uses of latest technology and the rights to states. It should include a ban on uses of facial recognition, remote biometric technologies that enable mass surveillance, similar for targeted surveillance, including so-called emotional recognition and gender detection technologies, fail to respect continuity and violate rights. You can see on this article, the declaration for studies specifically recognizes some of the particular rules in the space with regards to technology, information, communication, and information technologies, and specifically online gender-based violence, the creation of technologies that can generate fake media, and also certain types of surveillance technology. Therefore, the protection of these defenders requires an adequate use and safeguard of ICTs. We now move on to Article 18, which talks of the role and responsibility of business enterprises. The article states that in consultation with human rights defenders, business enterprises, including financial institutions and investors, shall ensure that their activities, actions, and missions do not restrict or violate the rights of those who exercise this right, shall identify, address, and remedy adverse impacts by defenders associated with their activities or as a result of these regulations. In particular, in safe and meaningful consultation with human rights defenders, business enterprises should engage in robust human rights and due diligence that explicitly includes considerations threats with violations of human rights defenders' communities and identifies and addresses gender-specific risks and impacts in accordance with the gender guidance or the guiding principles of business and human rights, developed by the UN Working Group on the issue of human rights of international corporations and all business entities. Article 18, which is the last reference to gender and women human rights defenders that the Declaration Plus 25 has, focuses on business enterprises, which, as we all know, have become a particular threat to all human rights defenders. But as always, they present specific threats for women human rights. Is why the article recognizes the business states and the duties of businesses or private sector actors in measures to effectively protect human rights defenders and analyze those situations that lead gender risks. As you can see, Section B cites gender guidance that includes rights. So I will take a second just to show you what the gender guidance is. And here is the cover of the gender guidance, QR code you can use if you want to access the PDF videos of the guidance. Let's see this type of gender dimensions that guidance has several guiding principles which actually guiding principle 2 indicating that states should set out clear expectations that all business enterprise domicile their territory and or jurisdiction of human rights to the operation. And administrative action means that states should require business enterprises domicile in their territory jurisdiction to respect the rights of women human rights defenders, whistleblowers, and guiding principle 16 is as the basis for embedding their responsibility to respect human rights. Business enterprises should express their commitment to responsibility for statement policy. In case the requirements policy of our discussion right now, the main aspect is that one of the administrative actions is that business enterprises should develop and review periodically a gender equality policy in meaningful consultation with organizations, human rights defenders, and the rest. On to guiding principle 18, states that in order to dodge human rights abuses, business enterprises should identify and assess any actual or potential adverse human rights impacts which they may be involved with their own activities or relationships. In this gender guidance, the guide indicates that identifying and assessing actual or potential adverse human rights impacts these enterprises adopt a very approach, drawing them to experts and conducting women organizations, grassroots organizations, women human rights defenders. And guiding principle 22 states for business enterprises this impact, they should provide for or cooperate with the processes. And action to do this is that business enterprises should show experience discharging their responsibility to cooperate with the creation of adverse impacts to the process. I will decisions emanating such processes and avoid targeting affected communities, including women human rights defenders, leaders. guiding principle 26 indicates that states should take appropriate steps to ensure the effectiveness of the mechanisms on addressing business-related human rights abuses, including considering ways to reduce legal, practical, and non-relevant barriers that could lead to united access to credit. One action to achieve this is that states should put in place mechanisms to ensure that no reprisals or retaliatory actions are directed at women, human rights defenders, and state-union leaders. Then, guiding principle 9 indicates that it is possible to that was early created by to establish and participate in effective operational level grievance mechanisms for individuals and communities who may be adversely impacted. This pretty much business enterprises to ensure that potentially affected women, women's organizations, women human rights defenders, meaningfully participate in administering operation level grievance mechanisms. Moreover, the composition of body process. Then finally, we have that it states that in order to ensure the effectiveness, non-judicial agreement mechanisms, both state-based and state-based, should be legitimate, accessible, predictable, equitable, rights competitive, and source of concern. Operation level mechanisms should also be based on and an action relevant to this aspect is that non-judicial grievance mechanisms collect certain data from the women's organization, human rights defenders, to enable gender responsive to return complaints, face any implication. Now, as you have seen, all of these guiding principles of business, the obligations of state actors and non-state actors to learn to honor human rights defenders are vast, and there are extensive standards and documents clearly explain how companies should and must protect and respect the rights of human rights defenders, and how states must take action to guarantee, respect, and protect these rights within the system. Keep in mind that all of these guiding principles are not part of the regulation. They are part of the guidance guiding principles in business rights. Guidance is good, but it is not intimately together. However, quite useful, and it is a source that you should take into account in analyzing the standards of standards. Now, finally, the articles we see right now are only some of those that mention the only human rights standards and the issues that the declaration inspired. And certainly, if you look at the rest of the declaration, you will find several other articles relevant to the protection of working issues. We hope that this information is useful to you, civil society, state actors, to analyze if state has actually complied with protecting human rights standards according to the standards, and to use this information to perhaps develop policies, actions, and laws to effectively protect. Again, it's truly a pleasure to be part of these discussions. If you have any questions, please feel free to share them with another. As always, I ISL this QR code that was seen right now. You can go to the page of the declaration, read the declaration and several other resources.
Итак, спасибо большое Хавьеру за то, что он подготовил
Thank you so
такое
much,
очень
Javier,
интересное
for
видео.
preparing a very interesting video. And I think that the materials that he presented, I hope that you had sufficient time to scan a QR code, to move to those documents, and you can keep in touch with Javier. You can always write to him. You can always talk to him, and I hope that we will stay in touch, and that the documents he shared, there are so many interesting things. We'll use it in our work. Now let me move to the next presentation. I would like to present to your attention Жанар Sikirbaeva. She is a human rights defender, and she's an activist and co-founder of the Kazakh initiative Feminita. Janar is Doctor of Social Sciences, Japanese University, and she is a journalist. She does poetry, advocacy on the national international level. She links social and economic spheres together. Janar, hello. The topic of your presentation is legal framework against discrimination. Hello, I am at another conference. We're expecting a big conference on LGBTQ rights. You know that we're dealing with defending the rights of LGBTQ, and we raised it during the third cycle of UPR when Feminita received 11 recommendations in the third cycle, and the government accepted. As you know, Kazakhstan adopted one recommendation from Chile mentioned by Javier to guarantee rights related to women human rights defenders working in the LGBTQ. I can do nothing because, well, I'm speaking from where I am. Some people hear me, some people don't. Let me write a message to you later. In terms of non-discrimination, we raised issues. In our recent report, alternative report, related to UPR, we had sessions with diplomatic missions, and we talked about LGBTQ rights that have been violated. And this year, we got 19 recommendations, and I think that it's a big win if we compare number 4 and number 3. In number 3, we got 11 recommendations for Sugi and 19 in the fourth cycle, and we hope that in the same way, the government in June this year will tell what recommendations is accepted, because if this is this recommendation which is noted, then we cannot do much advocacy. But when it's noted, when it's accepted status helps to proceed with the recommendation. In terms of non-recommendation, we participate in roundtables of the Ministry of Justice that raises issues on Anti-Discrimination Council, following the example of Moldova. Unfortunately, the working group that raises these issues does not include any activists from any of the LGBTQ initiatives. And unfortunately, I think that we cannot express our concerns and requirements for the anti-discrimination issue to be included on the agenda on a discrimination council or legislation. In Kazakhstan, still it's not available. In all of our laws in Kazakhstan, we don't have a clear notion of discrimination. There are legal documents in Kazakhstan we use in the courts in protection of our rights. What are the cases? For instance, dismissal, losing a job because of sexual orientation or gender identity. So people in Kazakhstan can be fired for that. Or transgender women are forced to show the evidence of their gender-based surgeries, and it's a torture, it's a discrimination because it's done by migration workers or workers in government agencies. Those who have prejudice against transgender people and we hear that ladies who are lesbian are discriminated. They are like sent to the churches to force them to change their orientation. So in order to be relieved from home arrest, they lie. They say, yes, they changed their mindset and now they are not LGBTQ. So other types of discrimination we tried to describe, but this year we had cases of transgender women being beaten, and a petition was discussed widely. It's still being discussed. The petition against propaganda of LGBT discriminations happen on the street, in government service, in government-related service. This could be hospitals, schools, migration, and even libraries. And many people, they don't understand where is the discrimination taking place. You are living, you are not killed, but there are cases which can show you very specifically what is discrimination against LGBTQ. And we expected a set of recommendations until the fourth review, and the first one is the same. I'm going to cite it. Anti-discrimination legislation to be adopted that is based on best practices and allow to fight direct and indirect discrimination and would allow to include such mechanisms as sexual orientation and gender identity as protected characteristics. This recommendation is still there. I'm voicing it, and we voiced it during the defense of our alternative report in Geneva last year. Thank you very much, Janar. I think that you are right. When there are concrete cases, concrete situations, the recommendations are very important for fulfillment. And I think that in terms of non-discrimination, support Musagali if you're ready. I know, Janar, thank you so much for a very detailed information and for your specific recommendations. If Musagali is ready, I think that he can cover non-discrimination issues in his materials, in his speeches. Musagali, are you with us here? So let's move to the next speaker. Musagali, you'll speak later. I think that the initiatives mentioned by Janar, they're very important. Musagali will speak later. And now let's invite, hello. Hi, Musagali. Let me give the floor to you.
Speaking of the recommendations of Javier and Janar, 139.44, 139.45, and so on and so forth. All people have rights for gender identity. People with disabilities, they must have protected characteristics. And we need to continue this work to ensure non-discrimination of women. And I will speak about people with disabilities. My main message is discrimination of blind people among other categories of disability. Although there are legal guarantees and non-discrimination provisions in the legislation, in practice, blind people still face barriers in access to information, access to education, infrastructure, and professional rehabilitation. Sometimes we see very bad cases of institutional discrimination, like a recent list of diseases when a blind person cannot become a judge. So people with some diseases, including blindness, they cannot become judges. Although Kazakhstan is party to Convention protecting the rights of disabled people, where discrimination on a disability characteristic is prohibited. Ensuring equal access to labor. Article 5, Article 13, individual assessment of professional abilities. Rather than exclusion because of disease or diagnosis. Creating reasonable conditions for professional duties. We have a national standard, Constitution of Kazakhstan, Article 14, saying specifically that there should be equality of everyone and a ban on discrimination against any characteristic. I do have an analysis of legislation, this legal act as of 2025. It's called the order, joint order between judicial administration and the Ministry of Health of Kazakhstan. When blind people cannot work in the court, whether you are a woman, regardless of orientation, if you are blind, you cannot do that. So it includes full blindness, diseases causing the loss of eyesight. This list doesn't contain anything to compensate for blindness thanks to technology assistant. For instance, assistance. These things are guaranteed by the convention and by Constitution of Kazakhstan. This is just formalistic medicinal nature. It's not based on functional possibilities. It just excludes blind people from the judicial process, although they can participate when reasonable conditions are created. So this order is against the Convention to protect the rights of disabled people and Constitution of Kazakhstan. In many countries, blind people can work in the legal environment regardless of their gender or orientation, whether blind or not blind. In Great Britain, there are laws with eye disabilities. They are provided with organizational measures, support measures. European Court of Justice Committee on the Rights of Disabled People underlines the need of individual approach and not exclusion because of the diagnosis. And I've got the recommendation for government agencies to revisit and cancel the provision of the order which it contradicts the international commitments of Kazakhstan, and prepare an alternative, offer assessment of abilities, and implement reasonable conditions to ensure access of people with disabilities to official duties and positions, including judges, and also conduct an audit of the legislation to see other hidden forms of discrimination on the principle of disability or gender. All people have rights. For the Human Rights Commissioner, the Human Rights Commissioner needs to give a legal assessment of this order, whether it's in line with the Constitution, Convention on the Rights of People with Disabilities, and international treaties. For the non-governmental sector, the recommendation is to prepare an alternative report, and it will be developed on the basis of our recommendations. Organize the human rights campaign in order to cancel discriminatory norms that violate people's rights, human rights, regardless of gender, orientation, or disability, or other rights that are violated. And it's unimaginable that in modern Kazakhstan, the citizens are excluded from some professions, especially in such key things as justice, access to justice. The government must remove such barriers and create conditions for the citizens, to everyone, without any exclusion. Thank you, Musagali. I think that your recommendations will be supported by people present here, representatives of the civil society, NGO sector. You can send us your examples. Our participants who care about non-discrimination, they can read your recommendations and support all your recommendations. Musagali has done a lot. He is promoting this, and you can find these contact details in social networks and in on our website. Thank you, Musagali, for high quality report. And let me apologize for the delay, and let me give the floor. The next topic that we'd like to discuss is access to justice and legal mechanisms for the complaints. The lawyer from Kustanai, Елизавета Жук, will speak about it. Couple of words about Елизавета. Since 2013, she has been working in the bureau. She is a consultant on all the issues of political rights, civil freedoms, and she's making a main focus on effective remedies: torture, discrimination, LGBT. Hello, not LGBT. Yes, we are talking about here not LGBT, but people without citizenship. And let me speak about the recommendations for Kazakhstan. Elizaveta, could you please turn your camera on? Thank you. In terms of recommendations for Kazakhstan, there are several issues and violations, first of all, related to reforms in the justice sphere and fulfillment of international commitments. Here, we can speak about several aspects. Let's start with the following. Its political influence on courts. The courts are very often under political pressure, and therefore they not always take independent decisions. So we need to strengthen the independence of judicial bodies, and there is a dependence of judicial on executive powers and legislative powers. And the judges in Kazakhstan assigned by president and other government agencies, it creates a situation when judges can be under pressure from the executive branch of power, and then the judges may take decisions to favor the executive power rather than law. And you know that recently we adopted a procedure, administrative procedures code, in terms of conflict between government and the person. And there was a lady from the Russian Federation. She went to a migration service to get the living permit, and they didn't give it to her. And the migration law says that the reason may not be shared. She didn't like it. She went to different bodies, and the explanation was national security checked her application, and they don't give any explanation. They say, no, we just don't give you the permit for residence. And she comes to us, and we go to the court. What's wrong in this situation? This is discrimination because she is from the religious community. We thought that this could be the reason in this situation, but it's not mentioned in the court even. National security, migration officers come, they say, no, we can't disclose the information. In the appeal, when we raised this issue, the response was the following. Let me cite it. The court asked the National Security Committee, what is the reason? Why? We made our check, but we cannot share the results of this check. And why I'm focusing on this? Because in administrative code, there is a principle of validity. When a person complains, relying on the government agency, it's like this person is guilty. It's like they have to prove that they did everything correct. And this is nonsense. The fundamental principles in this system and these mechanisms have been violated, and the government makes a decision in favor of the government agency without referral to any international documents. We got no comments, even in the court decision. So this is how the system works. It's about the independence of this judicial system. There is another example in our practice. We monitored a case on tortures. So there was a court investigation on tortures, and there was a case in the court as well. And every time the court postponed a court ruling, waiting for the investigative bodies to make a final decision. Once again, it shows that we have two different structures of power that are interdependent and that have impact on courts. So in terms of independence of judges, when courts try to take independent decisions, they feel pressure from high officials or political circles. It could be threats, downshifting, or even firing a person. We had a case when a judge made a good decision on a criminal case, and after that, this judge was downshifted to a different court. The conflict of interest. Judges may face a situation where they have to consider cases related to high officials or their relatives. It may cause a bias. This could be cases against oppositioners, human rights defenders, activists, and the decisions are made for the favor of the power rather than justice. So it's against the law. Also, we shouldn't forget the corruption in this system. It's difficult to comment. Especially in terms of the bodies that deal with these issues. Also, there is unequal access to justice. And some judicial processes are limited for some categories of people, especially the vulnerable ones. People with no money very often face challenges when they go to courts, because there are court expenses that difficult to pay, and also don't have an opportunity to use a qualified legal assistance because it's very expensive. So we have just limited number of issues for which legal assistance is provided free of charge. If we speak about the free of charge legal assistance, it's very difficult to get it. Although old people, they are eligible to this bona fide or free of charge legal assistance. Also, we've got a problem about the rights of women, national minorities, LGBTQ. Discrimination and violation of their rights are still a problem. Ethnic minorities, migrants, people with disabilities, women, they face additional challenges when they go to the court because of language barriers, cultural differences, and bias from the judicial bodies. I shouldn't forget a problem such as quality of court decisions. In practice, the court decisions are not aligned with the rights, human rights, and the processes could be too long. So it's a matter of quality of court decisions. Also, enforcement is another problem. When the court ruling is obtained, so there is a court decision, no matter whether it's a criminal case or administrative or civil case, this decision must be enforced. But in reality, the enforcement is slow or not enforced at all. So in this context, I'd like to say something about the inefficiency of the judicial system in general. If court decisions do not help and are not enforced, it undermines the trust to the court and make the legal system weak and non-transparent. At the end, I'd like to say the following. There is no proper control over the court decisions, means that the justice system does not provide real protection of rights of people. And court decisions are staying on paper, and this causes mistrust to judicial system and weaken the legal state.
there are some steps in the field of legal reforms, but they are not sufficient. Most reforms are very high surface and not in-depth structural problems resolved. So for Kazakhstan, it's very important to ensure independence of judicial from political influence, no corruption in judicial bodies, access to justice for all categories of people, especially vulnerable ones, better quality of court decisions through better qualifications of judges and reforms of judicial processes. And also we need to strengthen the system of enforcement of court decisions. The problems we are mentioning today require significant reforms and comprehensive efforts for the government to fulfill its duties. And I'd like to add here something that if the recommendations are not fulfilled, it means that we don't ratify the optional protocol of the Convention on Cultural Rights, and therefore our people cannot go to the Committee of UN dealing with these specific topics. If such problems are not resolved, then the court system will continue losing its efficiency and trust from citizens. Thank you so much. Thank you, Elizaveta. You presented interesting examples. What about the judges? Are they ready to stand for their rights? There are no cases for that. I'm not sure they are ready to do that, because for this, they need protection. They must be protected by someone. This problem is in the judicial system and as well as police, the internal affairs system. There is always a question, who will protect us? And we cannot fight with this system. Yes, these people are working in the system. It's very difficult to fight it, but I think that it's possible, but to some minimum extent. Integrated approach is required, but for that, people need to understand that. We are speaking about the efficiency of decisions. If a person knows initially that they will go and they will not get it, why would he or she spend time for that? A person must be conscious, and judges must be conscious, seeing that they have to do with people's lives. And we had cases when judges didn't study the documents, didn't study the legislation. It led to violation of the international treaty, the International Covenant on Civil and Political Rights. Heller's case, maybe you know it, on freedom of religion. Do you remember that they were prohibited from doing some customs in the place that they rented? So the religious community, they were free to do all that back then, but they couldn't. Unfortunately, we're seeing such examples, and we hope that thanks to the activities of your organization and human rights defenders, and non-governmental organizations on human rights who make their proposals, we hope these recommendations 139, 44, 45, and 15, and they say that it's needed to ratify the optional protocol to this international covenant, and other recommendations speak about a need to ensure the rule of law in terms of independence of judicial and right for judicial decisions to be of high quality. Thank you, Elizaveta, for the materials you shared, interesting cases. Journalists and human rights defenders and NGOs, they will use this information, and our government will listen to them. Thank you so much, Elizaveta. Now let me give the floor to, we'll speak about the following.
national mechanisms for the empowerment of women, advancement of women. Let me give the floor to Dilbar Turakhanova. She's with us. I'm seeing you online. Do you have any cases or proposals? Would you like to discuss the information that you've heard today? Dilbar is our last speaker. Let me try to reach you on the Telegram. I'm not seeing you. Do you have any questions or additional recommendations? Maybe we can discuss the cases. Musagali has shared some cases and recommendations. Musagali, can we publish your report? At the end, well, unfortunately, I don't see Dilbar because she was preparing a presentation and maybe she will reconnect. Unfortunately, Dilbar cannot join us, but she sent her presentation, couple of words. Let me show her presentation and share some information with you. Natural mechanisms for the women empowerment. She is a consultant on gender equality and women's rights. Presentation prepared by Dilbar. Let me show the presentation and then we'll have video interview with Dilbar and we will post it in Instagram and on YouTube channel. So let me give the floor to everyone who wishes to express his or her opinion. So we're finishing our first discussion and all the recommendations that have been given by our participants, they will be shared. You can watch our live broadcast in recording on the Dignity 51 page. And today, so we've discussed the following topics: legal framework and definition of discrimination. We discussed the women advancement natural mechanisms. We watched the video sent by Javier on the guiding principles, and also we watched so we talked about the legal mechanisms on complaint management. And I think that all the recommendations will be sent by you, if any. If you've got any suggestions, if you'd like to talk to our participants, add to their cases or co-implement some cases, welcome. And I'm finishing our live broadcast. All the best to you. Goodbye.